Govardhan. I'm a privacy expert in this field for around 20 years. I am also from the Netherlands, moved to Dubai a couple of years ago.
Great.
Yes, good morning everyone. My name is Irit Kist. I work as a data protection officer at the Netherlands Cancer Institute in Amsterdam, Holland. And I pursue my PhD research at Leiden University, which is one of the main universities in Holland. And actually, I hope to have finished the PhD research by the end of today. So I invite you next time.
Wonderful. And all the best for your PhD. So this is Raghavendra Kumar Verma. I am the Chief Legal Compliance and Risk Officer in ISON Experience Group. So I give you some insight about the ISON Experience Group. It is into the IT services and the customer care, and spread across Middle East, Africa, and Asia Pacific. So almost 52 countries now. So, and also I am the member of IAPP, that the International Association of the Privacy Professional. So I take care of, in my organization, entire data privacy aspect as far as the technology is concerned and compliance is concerned. So with this short introduction, I request Astrid to start with her opening remark, please. Yeah. So she is presenting one PPT. Yeah, Astrid, over to you.
So I'm here to tell you a little bit more about the trends in data protection and privacy in the Middle East. And yeah, so one thing is for sure, data protection is trending in the Middle East. Just waiting for my presentation to be pulled up. Thank you. So I'll give you a brief introduction and I'll talk you through trends in the UAE, in Saudi, Bahrain and Qatar. And I also discuss a few other trends in the Middle East. So to start with, what we see in the Middle East is that we have countries that have really big plans for economic growth, technologies, innovation, where we see Bahrain, Qatar, and Oman, smaller but very resourceful in diversifying their economy. The UAE at the forefront of this ambition, and Saudi also very busy and big plans for the diversification of their economy. So, yeah, what we see here is that the region is investing heavily in technology and automation, smart cities, fintech, scientific innovation. And yes, there are different approaches to all of this. So we have different levels of data protection maturity. We don't have a common approach when it comes to enforcement. So yeah, we have a wide range of expectations. So if we zoom in a little bit into the UAE, basically, we have three legal frameworks. One is the UAE Federal Privacy Law, which kicked in on the 2nd of January 2022. We are still waiting for the executive regulations to be published. Yeah, so we have to keep a close eye to it, because once they kick in, we will not have much time to comply. And then we have the Abu Dhabi Global Market Data Protection Law, which was updated in 2021. They basically added some elements that mirror the GDPR. And then the third legal framework is the data protection law in the IFC, where they have updated the law in 2020, and they are, actually taking really strong steps in terms of international data transfer, whitelisting with the UK. So zooming into Saudi, Saudi introduced its data protection law in September 2021. Companies have a period of 1 year to comply. So in this year, on 14th of September, you have to be compliant. And so what we have seen in Saudi is that the data protection framework is pretty much close to the GDPR requirements, although there are some differences. So one of the differences is, for example, the international data transfer, the data that transfers from Saudi outside of Saudi. We were first a little bit worried about data localization requirements in this legal framework, but they have opened up, although they do have some strict requirements when it comes to international data transfer from Saudi. So basically, the supervising authority will publish a list with countries which they consider as whitelisted countries, so safe countries to transfer data to, which is almost similar to the GDPR requirements. So zooming into Bahrain, there we have seen a legal framework introduced in 2019. Also here we see lots of similarities with the GDPR. And yeah, so if you're not compliant, you could even go to prison. Moving to Qatar, we saw there a PDPL law came into force in August 2019. The definitions and the legal framework here is also quite similar to the EU GDPR. Qatar also have some different zones, just like in UAE. They have free zones, financial center zone, which has its own privacy law. And yeah, so most of the laws that are existing in Qatar are similar to GDPR. And then other trends in the Middle East that we see. So now we have seen all these legal frameworks in these different countries in the Middle East. You know, what we're actually waiting for now is how these regulations and frameworks will be explained, interpreted, and enforced on. Now, in parallel to that, what we see in the UAE and Saudi Arabia is that there are really, really major developments with respect to artificial intelligence, the capabilities of it, new technologies, and those require also an introduction of legal frameworks. We don't have those yet, so I think that is really something that will come up very quickly. We also see that fintech is growing very fast and is getting really mature in most countries. We have to wait how the China people and the India data protection law will come into play in the whole evolvement of data protection law in the Middle East. So that is really something that we should keep an eye on. Yeah, so those were I hope with this you have a little bit of a more update of what's happening in this region with respect to data protection law.
Thank you, Astrid, and I will come back to you. Edith, please, your opening remarks.
Yes, thank you so much. As regards the European developments, I would like to zoom in on recent legislation. First, we have the Data Act that came into force. Then we have the Data Governance Act that came into force. Then we have the AI Act that will come into force. And then we have the European Health Data Space, as regards which a proposal was now submitted to the European Parliament, and most likely it will enter into force by the end of 2024 or beginning of 2025. So you can imagine we have 5 new acts, new European acts, on top of the GDPR that has already been into force since 2018. And what I see as an emergent trend here is that Europe continues to focus on legislation. On one hand, I would say that is good. Legislation clarifies norms and values of a respective people, its culture, and the countries beneath. However, what I do see is that Europe tends to focus on rule-based control rather than risk-based control. And I would like to explain to you what I mean by that. If I look at the Netherlands Cancer Institute, I'm sure you all may agree with me that it is of utmost importance that the data be shared throughout the world to search for similarities in cancer types, once again, throughout the world. Cancer is not restricted to Holland. Cancer is not restricted to Europe. Cancer takes place in the entire world. Yet what we do see is that the data sharing is obstructed. The data sharing does not take place throughout the world because of the rule-based approach, and also because of discrepancies between the interpretation as regards the rules within the legislation. Now, what I do see then as a further obstacle is that a recent case law within the European Court of Justice and also national courts has proven to create even more hurdles. I'm sure you've all heard about the notorious or famous, the way you want to look at it, Schrems cases, where data sharing with the United States was made illegal, after which, again, the privacy shields had to be renewed. We are already here with the third newest agreement between Europe and the United States. As regards other laws, other legislation throughout the world, the European Commission provides for so-called adequacy decisions to countries with a similar protection in its country in comparison to Europe. So, for instance, there is an adequate decision between the European Union and Canada. Now, also that is good. It's a good way of having your stamp as a country that you're doing well. However, in my view, and these are my personal opinions, it does not mean that if an adequacy decision was not granted to you, it's a lengthy procedure. In my view, it does not automatically mean that the data protection is not upheld well. And then, of course, when we saw these legal developments occurring throughout Europe, we had COVID. And we're all aware that COVID made it even more apparent that data sharing to combat diseases is so necessary in the world, and once again, throughout the world. So we saw promising steps. We saw that there were possibilities to have data sharing in emergency situations. I would like to utter, though, that the people who died from cancer during the entire COVID period was far higher than the people who died from COVID. I don't want to say that cancer is worse than COVID. I don't want to say that COVID is worse than cancer. I just want to stress once again that data sharing with each and every country in the world is important. Furthermore, also to avoid a bias in the data, we need to share the data, especially with those countries where you see a different background as regards genetics. We are such a wide diversity of people in the world, And once again, it is important that also the data and also the samples of those people in the world are shared because of genetic of different types. So far, the situation we are in now with data sharing for research that is still not taking place with the utmost possibilities, and legislation that is interpreted differently, as a result of which data sharing sometimes does not take place at all and scientific research does not take place at all. I then see the wonderful presentation of my colleague where I read the lines, yes, and then sometimes hear their legislation similar to the GDPR but stricter. If there is one advice that I would like to give to the legislators throughout the world is please bear in mind that the GDPR was intended to be a general framework. It is a general framework. It's not a must and you should and you have to legislation. It is a framework legislation. As regards the implementation, I do applaud with regard to health data that the European health data space is going to confine a lot of going to explain and clarify a lot of the concepts. And once again, I cannot stress enough that the innovations will have to take place. And the data sharing will have to take place as well. Final remark, and then I really am eager to hear from you as well. Final remark is that with the AI Act, the innovations are welcomed, and I think that is good. We have to be careful, I do think, with the fact that us individuals may not always be aware of what could be done with your data. I'm sure you've all read about scandals in the past where the data were shared without you knowing it and where your sensitive health data were spread around the world. Of course, the necessary precautions and technical measures will have to be taken, and that has already been provided for in the GDPR and has been provided for once again in the AI Act. So I leave it at that, and I end by saying that any suggestion from you in this final stage of my PhD that I could add, please feel more than welcome to talk to me in the break. So thank you so much. I give the floor to you.
Thank you very much. And a few points that I'd like to take from what in your opening remark. First, that the GDPR is just a framework. And I will take the liberty from what Astrid said. I take care of, I said that the 52 country compliances, and most of the countries, the law is copy-paste from the GDPR. Just the name change, that's the copy-paste of the GDPR. So whatever the lacuna in the GDPR, they exist in all over world almost. So one part. Second part, learning from the COVID. And right now there is a buzz about the disease X. So a few days back there was a seminar conference where that WHO head and many eminent people were there. They were discussing the danger about the disease X. Now how to combat with that, and that without sharing that that the health related data and the vaccination impact what is happening in the different individual, you will not be able to fight these diseases. So very well said. And I want to, the other emerging trend that I see in 2024 is the artificial intelligence and the impact on the privacy. The way we have seen that 2023 that the turn around everything as far as coming the ChatGPT. And ChatGPT that changed the world. Nowadays, we have seen that many companies terminated the employee. Now they are taking the help of the ChatGPT to draft the letter and so many things. So basically, all the AI, any machine learning algorithm, they needed data. And the plenty of data. And these days, like that platform like GPT, they are taking the data from that open source, that called the web scraping these days, that the open source, the internet. And although ChatGPT, after one lawsuit, they have changed something, but most of the AI developer right now, these days, thinking that taking the data from the open source, they are out of the preview of privacy law. Is it not so? As soon as our data is in the filing system, GDPR law or any privacy law is applicable to that. So if any AI developer, I don't know any technical person is here or not, but for we lawyer also, that we are helping to our company or our client per se. Give me 1 minute. So our client per se should at the time of they are developing the AI system, must be involved to take care how they are doing, taking from where they are taking the data, and how whether they are consent or not. Because if you are taking that data from that internet or some open source, obviously there is no consent. So how we are going to protect yourself? Second thing, these days a regulator are. So I ask few questions and anybody can reply. As soon as you open the Google and type one marketing stuff like you want to purchase this brand cloth, suddenly what you notice after some time? Anybody? Yeah. So suddenly that you are flooded with that same type of marketing stuff in your Google account. How they are doing that? They are doing a profiling through the artificial intelligence. They are doing a profiling. So and this targeted marketing profiling, a regulator are looking very, very seriously on that. Because they are doing your profiling without your consent, and the one of the major the part of the data privacy is the consent. Without your consent, your data cannot be processed, except some exception is there, but by and large, without your consent, no data can be processed. And they are doing so. And the funny part, like my colleague says, that the GDPR is just a regulation. The way the data is defined there, it is simply saying the data related to identified or identifiable person. So this can be anything. This is not any comprehensive and exclusive definition of data in the Data Privacy Act everywhere. So that's one major concern that need to be taken care by the AI developer as far as the privacy is concerned. And we as a lawyer, whether we are suggesting and advising our client or we are in-house counsel, because I am in-house counsel who is developing the technology, and I can share with you that we got a contract in UK for the debt collection. And we are servicing them from the South Africa. And what we are doing, we have a software that analyzes that the debtor who took the loan, their preference through the AI process. So, and there is no such consent right now. When we acquire this company, there was no such consent. Now we are building in-house how to take the consent, because without consent you are doing the profiling of the person who took the loan. That is against the data privacy. So what I noticed that these people is saying that these technocrats says that, see what we are doing. We are anonymizing the data. And this is also a misconception in my view, that anonymization of the data, as soon as you anonymize the data, you are out of the purview of the data privacy. Okay, but can you really do so? Can you really anonymize the data? Is it possible? First thing, you are open to the audit. Data Privacy Office will come and do your audit. If you're not able to prove that, then you are in the soup. The second part that the way AI is developing these days, the way AI is developing, the day is not far, and I read one article that even the anonymized data, you have the anonymized data, but your partner has not, and through the partner, they can identify you through your anonymized data. That means this anonymization is not perfect, and that means you are not out of the purview of that data privacy. So is very, very whosoever is developing that AI system must take care of the lawyer, their lawyer as a professional law firm or in-house counsel, advise at the time of developing the data how to take care of consent, how to take care of these issues. So I will rest my opening remark here. We'll discuss a few things about the AI and how to take care in the course of time. So another emerging point that I mentioned, and my esteemed colleagues mentioned about the health-related data, and we have seen that during the COVID, how the government used to share the health-related data, and they used and was able to develop the vaccine that really helped the humanity. So, Edith, can you highlight in which way can the principle of trust and transparency prevent legal disparities and promote data sharing to combat disease worldwide?
Yes, thank you so much, Verma. As regards consent, first of all, in the Netherlands, the patients sign 4 different types of consents. When they enter a hospital, when the need is for more information about the patient from another hospital, when they participate in a clinical trial, so for instance a new drug, and for the secondary use of their data. You can imagine that when the patients enter our hospital, the only thing they want is to get better. So they read or don't read all the packages of information, and basically they sign asking us, so where do you want me to sign? And so it is important that the data controller, so the organization, is transparent about its data processing. And in that sense, I think it's very important that at all times there must be clarity about which data, when, to which other third party, and how are the data going to be secured. And from the patient towards the organization, there needs to be a level of trust. It has been proven in research that when an individual does not have much trust in the system he or she lives in, so in a governmental system where he or she lives, that it could very well be that his or her trust also diminishes with regards to the data sharing. So I think good communication as regards the use and further use of his data is of eminent importance, so that he will be willing and able to share his data. As regards then the innovations and the general framework, I fully agree with what you just said, that we should be able to create a framework not only based on the rules, but based on the interpretation. And I think it will only occur with the principles of trust from the individuals towards the organizations, transparency by the organizations, and good communication throughout the entire process. Innovations must take place. I deem that, it does not make sense at all to believe, oh yes, we cannot do this because of the privacy. However, the privacy aspects must be taken into consideration at all times. So thank you very much for your question.
Thank you, Edith. Thank you very much. Astrid, you explain about the Middle East, entire Middle East jurisdiction and the data privacy, and that I noticed that the executive regulation in UAE is still not published, and they are waiting. And I know that Egypt also passed that data privacy law, but it's still they are waiting for the executive regulation. And but in the meantime, Saudi Arabia brought with a very robust law and in the line of the GDPR. So in your view, was or is still, what is the most challenging part in this legal framework that you mentioned about that?
I think the most challenging part, and Irid, you touched upon that as well, is the international data transfer. Whether it will be fully aligned with GDPR requirements or not. So what we have seen in Saudi is that at first they had a data localization requirement. It was pretty much closed, and then they slowly opened up. And everyone was looking to China. When China introduced the PIPL, there is a data localization requirement. And India decided not to include that. So that was good. But so the whole problem, and I'm looking at it as a corporate lawyer, so for me, it's easier to have a legal framework that is quite similar, because that can ensure a better flow of data globally, right? So the more they copy-paste the GDPR, for me, it's the better. It's easier, especially when it comes to the international data transfer. But I do understand the need that governments have to control whatever data is actually flowing out of their country. So yeah, there comes a political dimension into play, by which then a country will determine how far and how free data can flow. Any questions from you? I have not asked any of you if you have any questions for us. Let's engage.
Yeah. I have a question, if you don't mind. First, thanks for such a small session for data protection, which I know it needs more than small lecture or small timing. Yesterday we were talking about the AI itself and how it's implementing in our law firms. Of course, AI as an enforcement learning machine, it will require to be adapted with itself and it to be connected always with the internet. So how is the data protection can be working now? Because as we know, as the gentleman mentioned, yes, when you are just writing any data on the Google to search for it, then you are ready to be exposed with your data. But in the law firm, all the clients have so much confidentiality rule not to be exposed for their data or their problems. So AI and most of the AI is required by the law firm being rejected by them to be used in the law firms due to some risk of exposing their data by the AI. So what's happening in the background for that from your side as officers, STEAM officers in data protections? How you believe you can help law firms to use the AI with total security? And if the data being exposed, because as she mentioned before, the illegal spy which been exposed by US, it was surprisingly with that much data protection which happened in US, and even though they've been hacked and been exposed in the public. So how we can do that as a law firms, how it will help? Because one of the reasons which we cannot be developed is to use AI if we had a risk to not to have a data protections.
You want to take or should I take? So first of all, when we are taking that your data from your client, you are taking their consent in writing. Just must you take the consent in the writing that we can use your data, your case-related data. They will not agree.
Who will agree to expose this? Sorry to interrupt, but who will agree to expose his problems? He exposes his.
No, I'm not saying
papers.
that. Okay, I understand. Let me complete. So consent, you use your data for research purpose. Research purpose is the exception in any data protection. Research purpose, and research for your law firm perspective, or is to enhance their effectiveness or efficiency for your law firm. Research can be for educational purpose. This type of case, what law can be amended to take this type of litigation in the better way. So in the both way, you can take the consent. For your law firm, you can take the consent. For research purpose, still the consent is not required. So one thing is that. Second point, like I use one AI. I will not take the name of the company which I am taking. Obviously, you understand. But because we have a lot of litigation, because we are so many countries, and every country has the different law, and we are managing that. So we have one platform, and that we are putting the case, particularly for example, I give you the South Africa example. So South Africa, we have the large presence and the very, I would say, the very evolved country, and the data privacy is as good as the GDPR. Very robust framework for the normal people also, and for financial services also. So there is very robust system of the privacy in the South Africa. So as soon as you put some case in that system, they give you the predictability whether you are going to win this case or you can compromise your client. Okay, so we are using that. So from where this data is, this person is taking, because we are using, so already we are not the developer, so we take the third party infringement and that take care of the contractual, so we should not have any liability. But coming to your question, it's really typical issue that we legal fraternity is facing, and I can say that there is no concrete answer for that, no concrete answer, but I can tell you that now legal fraternity has started using this AI related software that is in the market. So, but still risk. You can, if you are not developing and you are taking that third party software, you can safeguard you through the contractual clauses that the third party IPR protection, you have taken the data from the third party, then you have taken their consent to build your AI system. Such type of protection you can have in the contract with your vendors. That's only the solution right now.
Yeah, and perhaps to add to that from the healthcare perspective, I do advise my hospital that the data be on the premises of the healthcare institute at all times, so they do not leave the premises. And that, of course, third parties are going to use the data and develop algorithms on the data to have a better analysis. I mean, it has been proven that the human eye can see far less than the artificial intelligence eye can see in detecting a tumor. But the colleagues who are developing those algorithms are not able to retrieve who is behind it. However, fully anonymous data in healthcare and health research should not take place, because you always need to be able to retrieve the patient behind the data. For the ones who develop the algorithm and the third parties, the data are anonymous. For the healthcare institute, the data are pseudonymous. So yes, I think there's what we call the wall between our premises and our data and the data sharing then with the third parties to prevent, as exactly what you say, that the data will get into the wrong hands. Yes, thank you for your question.
So thank you. So as you said about this data sharing about the healthcare system. So as one hand that the all healthcare practitioner is giving the more emphasis to share the data for the betterment of the humanity, to take care of the human life. At the same time, the regulator and the law body is saying that the health related data is the sensitive data. So what is your view, how to share this data in this?
Yes, thank you so much. Here we see on one hand the autonomous situation of the individual. He is self-determined in his data. It's about him or herself. But we also have the solidarity aspect where data sharing should be a fact in order to combat the diseases. In my view, I think it's of importance that, yes, there should be a balance struck on one hand between guaranteeing the self-determination and autonomy of the individual, and on the other hand, the solidarity of data sharing throughout the world. How could that be done? I think international code of conduct and international guidelines as to the ethical aspects of data sharing could be one part of the solution, where the patient, the individual, recognizes how important his data are for data sharing, but that at the same time, he can always object. He can always say at a certain point, no, it does not feel good for me to share my data for whatever reason. He should not be, let's say, punished for that. So his rights as an individual, as a data subject, should be acknowledged, and at the same time, the data flow should be as much as possible, is what I would say. And I really would like to hear if you have any other perspectives on this. Thank you.
So international code of conduct can be a legal instrument here?
Good points to utter. Yes, I do think it can be. It can be a fact. We see in the Global Alliance for Genomics and Health that an international code of conduct at present is now drafted. However, it should be practical for all the countries involved. So yes, I do think it could be practical. However, nowadays we still see many differences in the interpretation with regard to an international code of conduct. So those hurdles, once again, should be overcome. But as soft law, yes, it could be an instrument indeed. Yes.
Thank you. Astrid, from the UAE perspective, and UAE is a jurisdiction which holds the most of the holding company, and the subsidiaries are spread across the world. So as you mentioned about the data transfer, so what do you think that this UAE-based holding company, how to transfer data and like employee, for example, employee-related data coming to Dubai from the outside world to take care of the promotional aspect, employee performance review, and various aspects. At the same manner, the UAE-related employee data, citizen data, crossing over the board. So do you think any challenge into this and how to overcome that?
Yeah, so you will have to look at the rules that are applicable for any data transfer from the UAE outside to other countries and whether that is permitted or not. So on the UAE law, data transfer is quite flexible. If you look at the rules, it's not so strict as compared to Saudi, for example. So it's much more aligned with the GDPR requirements. You need to have those adequate levels of protection. You need to have those standard contractual clauses in place, and all of that. So you have to conduct the impact assessment, the transfer impact assessment, and then whatever country you're transferring to, you have to assess the impact on it, and then accordingly act.
And Astrid, what do you think what are the challenges you see in 2024?
Yeah, so I think one of the things that I really look forward to is the executive regulations in the UAE, but also the enforcement in Saudi. Hopefully, with all of these executive regulations, maybe guidances like we have in Europe, we will get more clarifications on all those rule-based legal frameworks that we have in place. So hopefully that will, so the question there will be, will it be also be much more aligned with GDPR or not? Or will the Middle East have their own distinct voice in that and have a different interpretation of the law? So yeah, I'm really looking forward to that development.
Thank you very much. And coming back to the artificial intelligence, and my colleague, gentleman, asked a very good question about the using of the AI in the legal field. We'll come to that, but before that, as I asked the question about the Google, and I believe that everybody, most of the people in here is Alexa in the house. How many of you have the Alexa in the house? Nobody. Wow. Siri must be there. iPhone must be using the Siri. So have you noticed that this technology is being used to do your profiling? Almost, whether it's Alexa, whether it's Siri, whether it's now Google is there. So they all use your profiling. And another issue is right now we are sharing our personal data willingly on the Instagram, on the Facebook. We put our picture, we put our reels there. I ask one question, please, and feel free to answer whatever you think that how you think that your data, your personal informations are protected there on this platform. Anybody, please. Any question? Anybody? Not protected? One? You? Please? Everybody pushed, I know that everybody on the Instagram, at least on the Instagram. So, yeah. So, how your data is safe there? No protection. Good. No protection. This side? This side?
You might say that there's so much data on the net, so your data would be so minimal, so that you say like it would lost between all the datas. Morally, it's protected like this. It's lost between all the other datas. But if someone wants to track you, he can track you.
So let me give you one perspective here. You can use it. You want to say something?
Yes.
Yeah, please.
Well, it's quite easy. We're all lawyers here. We just have to review the contract that we entered into when we subscribed, right? So if you check Instagram's contract, there's a little line there that provides that they cannot rent out or sell those pictures that you post. You just have to go through the contract and see that you are not actually giving away your personal data. As to your earlier comment on mobile apps profiling us, well, it's everywhere already. It even includes Spotify. If you use your Spotify, you have your personal DJ.
Very correct, very correct.
So when you play, click on the DJ, there's that DJ, an AI, introducing the program that's catered for you, and all the music that you love to listen to, it will play. And it will even play on the time of the day that you need it to be played. Okay? So, just an example.
Very correct. You mentioned very correct. Please clap for him, please. So I'm giving one perspective. Nowadays, deepfake AI is in talk, too much in the discussion these days. So as soon as your data in the filing system, you are very much protected in the GDPR. So even if you are sharing your data in the Instagram, Facebook, and whatever platform, social media platform, they are in the filing system. And as soon as in this filing system, you are protected. If somebody is misusing your data, because profiling can be of anywhere. They can take your political opinion or religious belief. So many things is there. So if they are trying